Good evening. This is Rahul Reddy. We're live here from Houston, Texas. Every Tuesday, we do bring in immigration updates. Emily, what do we have today to discuss?
Yeah, today we have the AR11 form, very simple form that everyone has to fill out when you change your address, letting USCIS know your new address. That form version has expired, so USCIS has been working on a new version of the form. And now all of a sudden, they've added a ton of new questions on this form, and they're clearly using it as some sort of screening tool. So, what changes are in this new version of the form? When is it likely to take effect? And then we'll talk about green card applicants, especially for employment based. Will you have to attend your green card interview abroad? Are you going to have to consular process now that we have this discretion memo on adjustment of status that came out in the end of May 2026? We're also seeing a lot of people facing delays in getting their OPT EAD cards, whether it's your initial OPT or your STEM extension. So, what can you do if your EAD card has not yet arrived? And then, lastly, we'll talk about secondary inspection at the airport. What kind of things CBP can ask you, whether they can look at your phone, look at your laptop, what are they looking for in order to let you into the US if you are a non immigrant?
Emily, first thing, when I looked into this AR11 form, it's now like previously it was just an address change. What's your new address? What's your old address? And right now, this is like a 10-page form. Everybody, anytime, 10? Sorry, I'm mistaken. Probably a little bit more than that. I'm counting 11-page form. But of course, 9 pages to fill out. 2 pages are just instructions. They made
Yeah. We've gone from a one-page form that you send in when you need to change your address, which is actually most people can do it online now through your My USCIS account. And all you had to provide was your name, basic information, your date of birth, country of citizenship, a number, maybe a receipt number, so that they can make sure they have the right person. And then your new address. That's it. I mean, all non immigrants are required to update their address with USCIS within 10 days of a move. So it should be a simple process like going to the post office to update your address. Now they've turned it into questions such as what port of entry did you enter at? What was your date of entry? When will your status expire? Provide your receipt numbers for all immigration benefit requests. Your employment and education information. They want to know who your current employer is and where they're located, or if you're in school, what's the name of your school and the address of the school. And then they have about I don't know, 7 pages of questions about public benefits, clearly related to the public charge issue when it comes to a ground of inadmissibility. And they have all these yes or no questions about whether you've gotten any kind of welfare, and then a list of 7 fields where you can list what welfare benefits you got, which of course doesn't really come into the picture for most people watching this. But the fact that they feel the need to ask all of these questions for a simple address change is just more of that extreme vetting. What are they going to do with all of this information? In my opinion, the target of this form is undocumented immigrants, so that they can get their addresses and find out if they have used public benefits, and they can then figure out how to more easily target them for deportation. But it does just create more hassle and confusion for legal immigrants when you're having to provide all of this information. What if when you move you're in between jobs, or what if there's an issue with your status or your I-94 or something happens while you are in the process of moving? Is it safe to fill out and submit this form with all this additional information? I will say that. Go ahead.
Emily, first of all, this is proposed thing. Most probably it's going to go through. And unfortunately, I mean, I have to advise people to fill this one whenever there is an address change. And I would also say that even for a green card holders, you are previously, we have never seen any of this one getting enforced. I've never seen anybody getting deported or having in trouble because of not filling the AR11 form. However, though, I want everybody to fill a AR11 form when they change the address. So, for example, every time they have an address, they have. I would rather recommend people right now to have the address change. Now, for those people who have not done address change, even if you're a green card holder, F1, H1, any other non-immigrant visa people, please fill the AR11 right now, because when the new AR11 comes in, then it's going to be much stricter. Now, even though you may not have filled the AR11 after you change the address, even if it's been more than 10 days, I would rather recommend you do it right now. Do you say anything different than what I say, Emily?
No, I totally agree with you. What is your recommendation for like F1 students? I see a lot of times when their parents are here on a non-immigrant work visa, the student came on a dependent, like an H4 or an L2 or something like that. They've been here their whole life. Now they've changed status to F1. A lot of times they keep their permanent address as their parents' address and they don't really update their AR11 form. They don't really provide their dorm address or anything like that, or their apartment temporarily while they're in school. Would you say those students now need to fill out the AR11 every time they move?
I think so. Yes, that's my
Yeah.
advice. Now, however, though, when it comes to the education, there are a little bit, there are rules where it says that if leave the F1 visa people out. If it's a US citizen going and staying, and your son is, let's say, staying in Atlanta, Georgia, Emily, after 1 year he can still cannot claim the local resident status, because he is there for the student purposes, is that right? So, but
Mhm.
still, when it comes to the F1 visa people, though, I would recommend that if you're staying in a DOMS, do change the AR11 right now. So this is a warning for everybody right now. Whoever has not filled an AR11 form, if you're an F1 visa, if you're an H1 visa, if you're a green card holder, if you're any non-immigrant visa, we want you to fill the AR11 right now. Now, there are a lot of people who came into United States. They have never filled the AR11 form, saying that where they are staying, they did not inform the USCIS. We want you to right now, you can go to AR11, you can fill it out. It's so easy. Even if it's more than 10 days, the rule says that you have to fill the AR11 within 10 days from the time you change the address. Even though if it's more than 10 days, we want you to fill it right now, because we don't know what this government will do it. Is there a chance that when you go outside the country, when you're coming inside the country, they may say, hey, where do you stay? And you say that you are staying in Atlanta, but you, on the contrary, the documentation does not say that you're staying in Atlanta. It may say that you're staying in Houston, Texas. We don't know if they would deny the entry. What if they will create a problem in when you go for the driving license? We don't know. So at this point of time, what the implementation is. So please fill the AR11. It's just you go to the AR11 site in the USCIS, you fill it out, you can submit it right now.
Yeah, and you can list, so the AR11, what they want is your physical address, so where you are actually staying and living. You have the option to also include a mailing address. So in the F1 student example I provided, you can provide your parents' address as the mailing address if they're in the US on a non-immigrant visa. So that important documents or any mail from USCIS still goes to your permanent address while you provide your temporary physical address in the form as well. So be aware that you can specify a mailing address separate from your physical address, but anytime you physically move, you need to fill out the AR11 within 10 days. And do it now before the form gets more complicated.
Emily, this question from Anirban has a very interesting question. My address has not been changed in my last H-1B and AOS filing. Is the AR11, does it apply for him? By filing an H-1B, by filing an adjustment of status, are we complying with the AR11, or do we need to file AR11 separately? My answer is
Yeah.
you have to file it separately.
Yep.
AR11 is a separate application. You informing the immigration by the H-1B saying that you're staying in Houston is not enough. We want you to file the AR11. You have any doubt whether you need AR11 or not, just fill it out right now. Emily, is that a good question?
Yeah, absolutely. It is very important to understand that filing any application, an I-539, an I-765, a 485, a 129, an I-140, all those things that you guys file routinely, none of that meets the requirement of notifying USCIS of your physical address, and that has to be done only through the AR11. So don't assume that by filing something else that you've notified them of your new address.
Interesting question. What about the B2 people? They're asking the question. They come into B2 and they stay in a particular address. Do they need to file the AR11? My recommendation is just file the AR11 right now, even for B2 applicants.
Yep, I agree.
So anybody, if you have never filled the AR11 form, you fill it out right now. If you have filled it previously, and if your address has changed, you need to file AR11. These are the two simple rules for the non-immigrant visa people and for the green card holder people. Simple. If you do not fill the AR11 ever in your life, if you're a non-immigrant visa and if you're a green card holder, I want you to fill it right now. And if you had filled it previously, one more time, I will repeat again. If you change your address, whenever you might have changed the address, I want you to file the AR11 right now, because we don't know how the government is going to implement the rules. What if the B2 visa person did not fill the AR11 form? Then he goes outside the country and he comes back in. You did tell us where you stayed, so we are going to deny the entry. Could they do it? We don't know. Yes, we may fight this case for you. We can go to court for you. You can spend all this money for you. But would you rather have us fight for you, or maybe just resolve the problem just for filing the AR11? I would rather file the AR11.
Absolutely. All right, green card applicants, are people going to have to consular process now and apply for their green card at the consulate, attend their interview for the green card at the consulate going forward?
Even though we got this memo on May 21st, 2026, Emily, that they may implement more strictly, saying that why you are not applying the adjustment of status. I have not seen yet implementation of this one. There are some very rare cases, especially when they are really not good cases at all. I mean, the case that only I saw an RFE was that that gentleman was illegally staying for a period of 10 years. Now that person has now married to a US citizen and then filed the adjustment of status because he entered legally, but he worked illegally for a long period of time. That's where they issued those kind of RFA. But in general, though 99% of the cases, I have not seen any problem. After that, I have a lot of my clients went to the interview. I had no issues. I had people who are parents of parents of US citizen that went for the interview, spouse of US citizen that went for the interview, green card holder spouse went to the interview, employment based applicant and the dependents went for the interview. Nobody yet has been asked any question on why you want to do the adjustment of status here. So at this point of time, we are not in danger on this one, but we definitely want people to keep coming to our YouTube channel, subscribe to our blog. If there is any change, we will inform you on that.
All right, next topic, OPT delays. We're definitely seeing delays for a lot of people. This kind of started with cases that were part of the adjudications pause for the list of countries that, they basically just said, we're not going to adjudicate your applications until we do all of our whatever public safety checks or whatever they're trying to do. That was, of course, struck down by a court. But even people who are not from those countries are experiencing long delays in OPTs. I had a consultation just yesterday with someone who has the job offer, has had it for a couple of months, and they keep having to push back their start date because they have not received their initial OPT yet. Same thing for the STEM extension. So I would say file it in premium processing is your number one rule, because obviously it's more expensive, but it is worth it. That being said, some cases even with premium processing are going with beyond the premium processing time frame. That makes it a little bit more difficult, but it's certainly not across the board. So most people are able to get it within the premium processing time frame. So that's your number one option to avoid these long delays.
Emily, filed my OPT. I didn't file in premium processing. Can I convert into premium processing? Same question. I filed my STEM extension. I didn't file in premium processing. Can I convert it to premium processing right now?
Yes, you can. And if you filed the I-765 online through your My USCIS account, you can do the upgrade online as well and get it done immediately.
And if you do it manually, you can even upgrade it premium processing. Either way, you can upgrade it to premium processing. Had no problem at all.
Yeah. And remember, for STEM extensions, you do have the 180-day automatic EAD extension. The problem is if you file, close to when your OPT is expiring, they're taking more than 6 months to process in regular processing. So we are seeing a larger number of people than ever who are running out of their automatic extension and still have not received the new card. So again, premium processing upgrade is your route there, but don't wait till the last minute to do it, because with OPT premium processing, the time frame is not 15 days, it is 30 business days. So it can take more like 6 weeks to get your OPT. So don't wait until you're a month away from, your automatic extension expiring and then upgrade. You need to do it at the 2 month mark at the latest, so that you have enough time in case there's an RFE on top of that.
And moving to the last topic, that we have seen the secondary inspection, other than when you come into the airport, there is a CBP officer and you normally come in, but there are sometimes they go to the secondary inspection. What kind of questions are expected there? Can they search? I'm speaking of non-immigrant visa people, though. I'm not speaking of U.S. citizens and green card holder. Can they search the WhatsApp? Can they search the emails? Can they search any of the other files and documents that they have before letting the person in?
Absolutely. Now, they you have the option to refuse to allow them to do that, but then they're going to deny your entry. So if you want to be actually given a chance to enter the US, you really have no choice but to let them search your phone. And so they're looking through emails, they're looking through bank statements, they're looking for anything that suggests that you may be violating your status. Maybe you're working when you're not supposed to be working. If they think that, if you're coming in as a tourist, but you have plans to do social media influencing and get money from all of your, things that you're posting on your social media, they can look at all of that in secondary inspection, and they can use any of that to not only deny entry, but potentially put you through expedited removal, which means that they're denying your entry and they're issuing a 5-year bar for you to be able to come back. So you need to make sure that your number one, everything you're saying at the port of entry is truthful, and that any documents and information and details in your phone matches that truth, so that there's no inconsistencies, nothing suggesting that you are doing things you're not supposed to be doing when you're coming in as a non-immigrant.
OPT and STEM extension people, we want you to be very careful when you are exiting the country and coming into the country. You need to carry the record, especially if the OPT people, they are allowed to do an unpaid internship. However, some of the officers may not be aware of it. And sometimes what happens is that the unpaid internship sometimes is going to create a problem. Hey, this doesn't look like an unfair internship job. It looks like a job, but you're actually not getting paid. I've seen the denial of the entry at the port of entry. I have seen people getting denied for unpaid internship because the officers did not understand what it is and they denied the entry too. So definitely, we are advising people who are on OPT and STEM extension not to travel at all. Even though they have a visa stamping, we are advising them not to travel. Anything else, Emily,
All
before we
right.
go to questions?
Oh, I think we can go to questions.
Questions that is coming with VVM9042 got laid off recently. And if I have unemployment for 6 months or more, um, and I want to upgrade my skills to AI, um, will that be an issue for getting the citizenship? No, it will not be an issue. But there is one other question he asked me, Emily, which previously we used to answer differently, and I want to answer differently right now. What if on the green card, can the green card holder apply for the unemployment benefits? We have told previously yes.
Mhm.
I'm a bit hesitant in saying yes right now because I don't know what rules are going to be changed, though. Because what if the Trump administration says that? What if the administration says that, okay, you are not a good moral character because you applied for unemployment benefits? Even though unemployment benefits is very similar to health insurance, which the companies pay for it, I'm a bit hesitant to say for the green card holders too right now. What do you say?
Mhm. Yeah, I agree. I feel like everything is discretionary right now. And public charge is also a big topic for this administration. So do they consider unemployment, proof that you're using public benefits? No, it's not a public benefit, but because they have discretion in a lot of these adjudications, especially for citizenship with good moral character, as you mentioned, it may be best to avoid taking advantage of the unemployment insurance if you're a green card holder right now.
Very interesting question from PM UO44, whatever it is. um, um, I have moved multiple times. I did not fill the previous address was not on the record of the AR11. I'm on H-1B with the current address on the H-1B. Do I need to should I fill the AR11? Absolutely, you should. Fill it right now. You be compliant from now onwards. Even if you may or may not be compliant previously, I want you to do it right now.
Vijay says, can I apply for compelling circumstances EAD when my H-1B extension is in process? It depends on whether your previous H-1B has already expired because the compelling circumstances EAD requires you to have valid status at the time of filing. If your previous H-1B has already expired and you're staying in the US based on the pending extension, then no, that will not work. But if your previous H-1B has not yet expired, you maybe filed your extension early, you can file it at that point.
I have an approved EB1A I-140 and a plan to file my 485 soon. I recently received a better job offer with H-1B transfer, and the new role has similar duties. Hmm. Technically speaking, I'm assuming that you filed the EB1A by yourself. Technically speaking, about EB1A is definitely is on your merit basis, though. As long as you are in the similar field, I don't see any problem. And you file the adjustment of status, I want you to declare, write a personal statement that your job that you are doing is in the same field as what your EB1A has been approved. He has a priority date of 2017 through EB2, and he converted to EB1. Yeah, that looks good to me. You should proceed with you can proceed with the new job. I don't see any problem with it.
V1MS says, if I re-enter the US with my AP combo card, am I still considered to be in H-1B status? I don't want to use my EAD since my kid's age is not locked yet. So as long as you come back to work for your H-1B employer under the terms and conditions of your H-1B in the right work location, the right job title, the right salary, right job duties to all match your H-1B, yes, you can still be considered in H-1B status. You can extend your H-1B as you normally would, and you're not using your EAD in that situation.
Question. Uh, I'm pursuing a PhD. I'm expecting to graduate soon in April. How soon can I apply AB1? What is the practices to be followed on? I have right now have an EB2 approval. This question is coming from Vihari Verma. Here's the thing, though. Doctorate degree is not an automatic ticket for EB1 qualification, though. There are two things. One is EB1A and EB1B, and there's also EB1C, which I will not consider you for EB1C, but EB1A and EB1B you need to consider. So none of them say that you need to have a PhD. It's not PhD. Just because you have a PhD doesn't automatically qualify. So you have to meet the parameters of the EB1A. In the case of EB1A, they are now not only looking into which requires for EB1A, you have to meet 3 out of the 10 requirements, but the USAS is also putting a condition. What is the impact on the society that you have? Is it extraordinary for the society for you to get that benefit? They're also looking into that. Definitely for EB1B, which is outstanding researcher, if you're working as a researcher and if you are in the research field, if the company has two other doctorates or research field research people working for it, it may become a little bit more easier. But for the EB1B, the company, not only you have to be qualified, but the company also need to be qualified to file a EB1B, and the company must be willing to file a EB1B. So you need to look into all these parameters, not that you get an EB, just you get a PhD. Hey, here is my PhD. Give me the EB1. That doesn't work that way. There are some exceptional cases where you say, "Ah, okay, I won Nobel Prize, I won an Oscar award." Definitely. They don't need anything. Just you send that Oscar award or Nobel Prize, they will give it. But PhD is not the same as Oscar or Nobel Prize. So you need to look into all other parameters.
Hare Krishna says, I am an H4 kid studying engineering in my second year. Me and two citizen friends are working on a startup idea. We're pitching for venture capitalists. Can you please advise if I can work on the product? You have to be really careful here. There's a point when a hobby turns into unauthorized employment for an H4 holder. So, one of my friends, Sarah, is a DSO at a university, and she had a really good way of kind of analogizing this. So, think about if you are just really into cars and you are walking by from your dorm and there's a mechanic shop that you walk past every day, and you start kind of looking in the window, looking at the cars, start talking to the mechanic guy, and ask him a lot of questions, and observe what he's doing, and look over his shoulder, and you want to learn everything you can about cars. You're obviously not employed by this mechanic, and you're not working. That's different than now you're coming into the mechanic garage and you've got the tools in your hand and the mechanic is telling you what to do, and you're getting paid for that, or maybe not getting paid for it if you're trying to claim that you're volunteering. But if you are doing work that a mechanic would normally do, you've now crossed the line. So you really have to think about, is this a hobby right now, or have we crossed the line to the point where this is actually a business and I'm doing something that's actually not authorized?
Question that's coming out from Giri is that what is the A number in the AR11? Is it the same of I-94 number? No, A number is not I-94 number. If you don't have an A number, if you don't know what the A number, you can leave it blank.
Prasant says, as per the latest stay on the court case, do I need to pay the $100,000 fee? Because even though I've been counted in the cap, my new employer is going to consular process due to a denied B2, but I was counted in the H-1B cap in 2011. So the $100,000 fee has nothing to do with whether you were counted in the cap or not. It is 100% dependent on, is your company filing for consular processing? And if so, do you have a currently valid H-1B visa stamp in your passport? If you are consular processing and you do not have a currently valid H-1B visa stamp in your passport, the $100,000 fee does apply. The court case, yes, it was struck down, but that decision striking it down is currently on hold, and that hold may be extended, which means the $100,000 fee is still required. Now, during cap season, because it was very much in flux, we did file cases without the $100,000 fee, knowing that if it is in place, we do have to pay it. And we can fight about that later, but we did at least get receipt notices so that we can show that we did file by the June 30th deadline, and then we can always come back and pay the $100,000 fee later if it's decided to be required.
Question with regards to my son is about to age out. We are waiting for the EB1A priority date. If my son moves to F1, is that going to negatively affect son or the family? No, it does not affect the son or the family. There's one thing. Even if the child is on F1 visa, though, if the priority date becomes current, and if the child is under 21 and in under Child Service Protection Act, if you don't know what that is, you may want to research on that one. If the child is under 21 under Child Service Protection Act, Even if the child is not a dependent, even if he is not an L2, even if it's not an H4, you can still file the adjustment of status even if your child is an F1.
Sanjay says, I'm on EB2, priority date's October 2013. And a few weeks ago, USCIS sent an RFE asking for the medical exams because they expired. Is this a good sign? It could be. Obviously, EB2 is completely unavailable right now. So why are they spending their time asking you to submit medicals if they can't approve your case right now? It could just be an officer that is bored, needs some work to do, decides to get that done, even though your priority date is not current. On the other hand, it could be USCIS knows that on October 1st, next year's green cards are going to be coming out and they expect that your priority date will be current. And therefore, they want to make sure they have all their ducks in a row so that they can approve in October. No way to know which one of those it is. It's anybody's guess, unfortunately.
Question from Lalita. 539 has been denied due to USCIS error, legal error. We filed the motion to reconsider. How does the USCIS take a decision? How often are the MTRs approved? I would say the MTRs or approval rates are depends on the case. Definitely, that's a normal word. But in general, if I have to answer that question, it will be between 10 to 15%. Here is the other problem, Lalita. Though, once your I-539 has been denied, from that time you are counting the unlawful presence. Though, you may have encountered unlawful presence before that, which I don't know. But as per from the I-539, you are counting the unlawful presence. And the USCIS takes this motion to reconsider. Sometimes they do it only 2 to 3 months. Sometimes they take 1 year to do it. So let's say they take 1 year and the motion to reconsider is being denied for you. This is what is going to happen to you that at that point of time, you have accumulated more than 1 year of unlawful presence. Your motion to reconsider will not pause the unlawful presence. If it only gets paused if the motion to reconsider has been reconsidered, reopened, adjudicated in your favor, then you will get that they will pause it. So in 85% of the time, what happens is that when the motion to reconsider has been denied, you have stayed more than 1 year unlawful in this country. That means that you will have a 10-year bar. I want you to be very careful on this I-539 waiting for it. You may want to take an independent decision of leaving the country if you don't have any other status, because otherwise, once you have the 10-year bar, then if you leave the country, you're never, for a period of 10 years, you can't come back.
Then she says, when will the 180-day unlawful presence start? Is it either the extension denial date or the I-94 expiration date? My case was pending for more than 180 days and denied, filed the extension before the I-94 date. Okay, so before your I-94 expires, you were maintaining your previous status and you filed your extension before the I-94 expires. Once the I-94 expires, you're technically no longer in status, but you are lawfully present. No unlawful presence happens while your extension is pending because it was timely filed, and I'm assuming it was not a frivolous extension. That means once your extension is denied, unlawful presence begins the day after the decision of the denial going forward, does not go backwards. Out of status time goes backwards to when your I-94 expired, but unlawful present time starts from when the decision is actually made. And there's a big difference between being out of status versus unlawfully present. One of them creates a bar to being able to come back to the US, the other one does not. And it's very tricky. I mean, even, attorneys get tripped up on those and get them confused. So it's very important to understand the difference and know when your clock is ticking.
Question, can a compelling circumstances EAD be applied when the H-1B extension is in the process? Yes, you can apply, but the problem with the compelling circumstances EAD is once you go into compelling circumstances EAD and your extension, you're not relying on the H-1B extension, you're going in the compelling circumstances EAD though. you cannot come back to H-1B. You cannot move back to a legal status in the United States. And if you want to come back to an H-1B, then you have to file a consular processing. And as Emily has described previously, if you do the consular processing, you will be subject to $100,000 fees at this point of time. So consular accompanying circumstances is very dangerous at this point of time.
Charmine says, any insights or estimates on the EB2 or EB3 priority date? What could it move to in the October visa bulletin? Well, we always say we're the worst at predicting these things, but what I can tell you is I did check the latest statistics. USCIS did update them not too long ago. They were published not too long ago, but they go through April 3rd, 2026. At that time, there were still 25,000 EB2 India 485s pending with priority dates before January 2015, and 15,000 EB3 485s pending with priority dates before January 2015. So that's over 40,000 applications. Now, this year we do have spillover. There's a total of 186,000 green cards available for employment based. 28% of those go to EB2, 28% go to EB3, then they're capped at 7%. So ultimately, EB2 gets 3,600, EB3 India gets 3,600. So we have about 7,200 available this year and 40,000 plus people in line. That would suggest, assuming the same number of visa availability in the coming years, that it's going to take 5 years to get through the 40,000 that we still have pending. Now, why is it that the filing date is showing as January 2015, as if we're going to get through 5 years worth of green cards by the end of this fiscal year? I don't know. Could it be that they're expecting a ton of spillover from family based and the certain travel bans that are happening right now? That's anybody's guess. That's where we just don't know. But the numbers don't make a lot of sense for where the filing date is right now.
Emily, one little thing on the 3,600 calculation is that you're basing that 3,600 is guaranteed for Indian nationals. They will get that much. But what if the other country nationals are not using it? Particularly at this point of time, the final action dates for the EB2, EB1 and the EB2 for other nations says it's current. So in the 186,000 though, whenever they don't use the other nations, Indians may take the unused ones. When I looked into the employment based for the EB3, even though the priority date says August 2024, there may not be that many. Do you have any stats on how many other nations' applications are pending, or you don't?
Yes, but I don't have them handy. I can
Right,
try
right.
to pull
Okay.
it up real quick.
So there may be some hope that we may get more, Indians may get more than 3,600. While you look into it, I will go into other questions. Question from PM meeting. Can I be unemployed few months during pending I-485 application? If you're the primary applicant, that will endanger your green card, though. If you are, that will endanger your green card. If you are a dependent, I don't have any problem in you being unemployment. But if you are the main applicant, it may endanger, it may have a problem for you to get the green card.
Okay. Rest of world, as of April, there were 12,800 485s pending.
That's EB2 and EB3 combined. The rest of the world
That's
may not.
just that's just EB3.
So that's where I feel that maybe some of the unused things may pop up into the family-based immigration. When you say 180,000, we still have about 4 months left out. So there may be some unused by the other country nations, maybe used up by Indian nationals. Maybe.
But they made India unavailable for EB2. Can they even, I'm assuming they've already taken that into account.
Consideration, yeah. You're right. I'm sorry, Emily, you're right. Yeah.
EB2 rest of world, there's 35,000 pending for
Okay.
EB2.
So yeah, they made EB2 unavailable, but EB3 is still available. So if there are any applicants, they may adjudicate the application. But yeah, yeah, we'll see in October. I have a lot of hope, but then We both are the worst people in predicting the priority date.
Yeah, for sure.
um, Bitcoin has this question: will the H4 application during the 60-day process pause the yeah, within 60 days if you file a H4, you are in a safe position. Absolutely, very good. And can I apply the H-1B because my H-1B I-94 is expiring in 2027? Yeah, you can apply the H-1B before the I-94 expires. You can even apply the H-1B after the I-94 expires of the H-1B. There's no rule that you have to get the job within the time your I-94 expires for you to move back into H-1B. Now, one caveat is that you can only use up to 6 years of the H-1B unless you have an I-140 approval. That rule, you already know that. As long as you're complying with that, you can switch back to the H-1B, not within 2027, 27, but you can do it even later on too.
Sailaja says, I'm applying for my driver's license for the first time, and they gave me the validity as per my H4 EAD, even though I had the H4 and visa stamping valid longer than the EAD. Why? Well, my first question would be, did you give them the EAD along with your H4 and visa stamping? If so, most of the time they're going to choose the EAD to go through the saved system because the EAD is one document by itself that covers your identity and your lawful presence. If you had given the I-797 plus the visa stamping, they should go by that date, but now they've got two different documents to look at. One of them establishes identity, one of them establishes lawful presence, is a little more complicated. That's my best guess. But if you never gave them the EAD, then I have no idea. If that just means that's what's in the save system was your EAD end date, not your H4 end date. You can do
Emily,
a save self check to find out kind of a little bit of what's in there.
what is that? Emily, can you tell me what is that save check again, Emily? So that
Yeah, it's kind of related to E-Verify, but so SAVE is the system that connects various government databases, federal government databases about your social security and your immigration status. And it allows states to use that information, connect to that database to verify that you are actually lawfully in the country. And so every time you go to renew your driver's license, you give your documents over. They're not just going to look at your documents and say, here's your driver's license. They're going to run those documents through SAVE, and SAVE is going to tell them, yes, this person is authorized. You can go ahead and give the driver's license or not. Sometimes that save check takes 30 seconds, sometimes it takes 30 days, and there's no rhyme or reason to it. But there is a system called the save self check where you can actually go in, enter your information, and it will tell you what the status of the save process is for you. If you're like waiting to hear back from the driver's license office. And you can also do an e-verify self check, which allows you to put in your information and see whether USCIS agrees that you are authorized to work. So if you're, ever in a question like, oh, am I in H4 status or am I in H-1B status? I'm not sure based on when approvals happened or when I traveled. You could try to look up that e-verify system and see what is showing there.
I want you guys to subscribe to our blog at rnlawgroup.com. We're going to publish an article on that soon so that you can have all that information of the web links where you can go and self-check yourself for the driving license and also for e-verification. Very good information, Lee.
Sudendu says, I filed for AP along with my EAD in February 2024. Received the approval of the EAD, which is valid for 5 years, but my AP is still pending. Oh my gosh, 2.5 years. Raised multiple service requests. It's still in pending status. Is there any other option I can try to get the application expedited? Litigation is going to be your best bet. Definitely after 2 years, it is an unreasonable delay. Litigation can be expensive. So that's definitely something to take into consideration. I mean, the only other thing is to just file another one. Obviously that's $630, but that's cheaper than litigation. And a lot of the New ones are, depending on where it's going, it might come through relatively quickly through the NVC, but even there's just no rhyme or reason to these processing times. It's ridiculous.
One question that is coming for Anirban is that it's not a question. He has given a suggestion to everybody else. While I'm on this, I file my AR11. Super simple. Thanks.
Good.
That's a very good job. Please, this ban has done a very good job. I mean, you have never done AR11, you can just do it. You have done it, but you have not updated, do it. You have any doubts, just file the AR11 right now, be on the record. Thank you, Airborne, for telling other people that simple, super simple right now. It is super simple right now, but we don't know, in 1 week or 10 days, it won't be super simple. Oh my goodness, it is like there's all pages in here. No? These are
That's a
pages.
lot of pages.
Airborne, you just
You missed out
still
on all
going.
that.
Yeah. So please do it right now.
I think maybe we should make people only take questions from people who confirm they've done the AR11.
Yeah, that's
Um,
probably, yeah. That will be encouraging people to do AR11. Yeah. So yeah, we'll probably start implementing that, Emily.
all right.
We have a daily Zoom call, guys. If you have any questions, you can always come to the daily Zoom call. I probably will start implementing that, Emily, because we
uh,
want you guys to be safe. We don't know how the immigration is going to act it. So if anybody has done AR11, if you have any questions, we're going to promote you guys. Questions
Rajiv
from.
says,
Go
I'm
ahead, Emily.
in
Sorry.
H-1B grace period and I'm thinking of changing to B2 status. What are the implications? Right now, the implication is there's no going back from B2 status, most likely. We used to be able to file a change of status back to H-1B when you got the job offer while the B2 is pending. That's no longer an option. So you have to wait until the B2 gets approved and then file the change of status to H-1B. Problem is, you ask for 6 months on the B2 and it takes 6 months to process. So by the time you get it, it's either expiring or you have to leave while it's pending because you hit the 6 month mark, or you have to file an extension of the B2 while the first one is pending. And now you're in the same boat again, waiting for the second one to be approved before you can do anything. So it's not a great option anymore, unless your plan is literally to file the B2 and then leave at the 6 month mark.
Question from Ratnakar. Do I need to file AR11 for everybody in my family? H1, H4. Yes, you need to file H1 and H4. All the people have to file separately, though, unfortunately. But it's very simple. As Irvan is simple, I mean, just very simple, guys. The form is very simple for you to fill it out. Okay. Just give me 1 second. I-140 has been
Oh,
approved.
sorry.
You go ahead, Emily.
Rajesh says, my son filed for the OPT in premium processing. Then he got admitted to a master's program and got his new I-20. He initiated a cancellation of the OPT. Will he get his premium processing fee refund? No, he will not. Once it is paid, you do not get a refund unless USCIS goes beyond the 30 business day processing time. Otherwise, that money is gone.
Venkat Gulla, he was traveling to Niagara, wanted to see Niagara. He happened to have an impact. He has H-1B extension pending. He had a turnaround. Because of this travel history, will that cause any problem in his H-1B extension? First, I will explain you what this turnaround, what Venkat Gulla is telling, though. When you go to the border, either to Canada or to Mexico, though, what he meant to say is that he crossed United States and went into Canada. He didn't knew that he was going to Canada. And believe me, this mistake is done by so many people. And Emily has lived in Michigan. She knows a lot more, but she has traveled a lot of times to Canada for a lot of different reasons. But it's very, if since you already have the H-1B this gentleman has Venkat has the H-1B approval, which is still valid, he was able to come back into United States. If the H-1B has expired, for example, if H-1B is expired in June of 2026, he filed an extension in May of 2026, and the extension is still pending, he would not have been allowed to come back. Since luckily his H-1B is still valid, he was being allowed to come back into the United States. There is one guy recently, I just spoke with him today. The same incident happened in Mexico. This guy went into Mexico. He didn't realize that he went to Mexico. And all of a sudden, he realized he's in Mexico and he wants to come back. He doesn't even have his passport and H-1B. So, luckily, his wife is. Somebody is shipping it, and then they're shipping it to Mexico. So he will have the passport, and he luckily his H-1B is still valid, so he can come back into United States. But I want you guys to be very careful when you go near to the border towns, Niagara, El Paso, McAllen, Laredo, these places, and some parts of San Diego, when you go south of San Diego, we want you to be very careful when you're going. Whenever you go, mark it out where the border is, how many miles it is. And 10 miles before that border, start pushing the car. Don't even drive the car, just push the car from the back. Now, that's how I want you to be careful, guys. Because once there's no way you go there, you can't come back, you will have to turn around. That means that you go to Canada and then you come back. When you come back, you're going to go through the immigration.
Yeah, and some of them are tunnels. You definitely cannot turn around in the middle of a tunnel.
Yeah, you.
From Detroit. Okay, Siva Kumar says, I filed my green card in 2022, priority dates 2014, both EB2 and EB3 still pending. My son turns 21 in December this year. He has a valid EAD AP. Do we need to file F1 for him? You need to look at number one, is his age locked? This will depend on when your I-140 was approved, when your 485 was filed. If his age is locked and you're sure of that, then he could potentially just rely on the 485 because he should be getting the green card. So as long as there's no issues with your green card, then he should be able to get the green card. But if his age is not locked, then you need to look at what is the likelihood that the green card will be approved not by December 5th when he turns 21, but by December 5th plus the number of days that your I-140 was pending. And in your case, it's a little more complicated because you have two I-140s. So which I-140 date do you use? It depends on which one your 485 is based on. And if you've done any transfer of underlying basis, you need to know which one your current 485 is based on. How many days was that pending? Add it to his 21st birthday. That becomes your new deadline. If there's no way that he's going to get the green card by then he does need to do an F1 because he's going to age out. So if you know that in advance, that you can pursue that now.
V5485 for myself and my wife. My spouse H4 was revoked in 2014 due to underlying H-1B has been withdrawn. As I choose to join other company, we didn't mention denial in spouse's 485, any issue. I don't know what you mean by H4 was been revoked due to underlying H-1B. You can always supplement if yeah, I couldn't understand it, but if you have not informed the USCIS, it's always good to inform them. What you can do is that you can do the interfiling and send it to the address where you mailed it to the USCIS with the 485 receipt notice. Put a cover letter saying interfiling. This is what happened in the H4 inadvertently that you did not mention about it. So you can be on the record. So later on, if they come back, hey, why didn't you mention it? Yeah, once I realized it, I mentioned it. Please look into the interfiling. Make sure you keep a FedEx tracking record of that one.
YGSHSBL says successful mandamus. Priority date was May 2014, EB2 India. Filed the 485 in April 2022. Filed the mandamus lawsuit in April 2026. Got the green card approved May 27th, just a few days before the dates retrogressed in June. Litigation does work. When your 485 has been pending forever and these dates go forward and back and forward and back and then completely unavailable, the next time your date becomes available, litigation can be the route to go so that you get it over with, so you don't have to keep listening to us every week going forward.
There's a lot of backlash on people that says that, hey, Trump is not nice guy, and Trump administration is not nice people, and you are telling us to go to litigation. Will they take a revenge? Well, if they want to take a revenge, the first people they need to take a revenge is the Supreme Court justices. They are the people, because they blocked him on the citizenship. They blocked him on the tariff. They blocked him on so many different things. So if the Trump administration wants to do anything, the Supreme Court justices will be in the first in line, guys. You will be last in line. And then probably Emily, me, and Stephen will be in line too.
So Haman, she says, if I'm an L-1B, just got my visa renewed, can I do a change of status to H-4 EAD? Spouse has an approved I-140 and stop my 5-year clock so that it's available as a backup in the future. Yes, you can do that. So the time that you spend on H4 does not count towards the L1 limit, which is not the case for H1B. H1B time does count, but you should be able to stop the clock so that you could convert back to L1B in the future.
Question from Arvashal. Got the green card last week in EB1C. Can I travel to Canada on a business trip for 3 days? Anything I need to be careful about? You said you got the green card approval, or you got the green card. There's two different things. If you got the green card in hand, I don't see any problem in you traveling to Canada. But if you got the green card approval online, but you don't have the card in hand, I do not want you to travel. I want you to wait until you get the card. If you have a card, absolutely, you can travel to 3 days. Other than the green card, of course, I don't have to explain you that you have to carry the passport. That's it. You are good to travel for 3 days to Canada. No problem. Anything else?
Last question here. Pratu says, I got the L1 extended for 2 years, but my dependent spouse and child got only 1 year. Did not get any response on extending theirs for 2 years. What should I do? First thing you got to do is try to figure out why. Was it based on what end date was listed in their I-539 form? If the I-539 had a typo and only requested 1 year, there's nothing you can do to get it corrected other than 6 months from now filing another extension for them. If it was correct in the I-539, then you're looking at just keep doing service requests, but it's likely that by the time you get any answer on the service request, they might be close to that 1 year extension because it takes so long to get anything out of them that you might have to file the extension anyways.
Anything else, Emily?
Nope, that's it for this week. Thanks everybody for joining. And remember, fill out your AR11 before the form gets even crazier. And stay tuned. Be sure to subscribe so you get all of our updates.